Thank you. Yes, let's proceed.
Mr. Chief Justice, and may it please the Court, John Foskett for the defendant appellant Miko Rose. With me is Regina Hurley. At the outset, I'd like to alert the Court to the fact that the parties have agreed to a convention of referring to the two children in this case by their first initial. Those initials will be J, who is my client's daughter, and M, who is the plaintiff's daughter. This case presents two significant issues regarding parental rights and responsibilities in Massachusetts. The first is whether or not Massachusetts is going to confer parental status with all of its rights and obligations based on a California registered domestic partnership scheme which clearly violates the Massachusetts Declaration of Rights.
If they had stayed in California, is there any question but that both of these children would be both of their children?
If they... That's an interesting question because, as you know, we have this pending litigation going on with Proposition 8. And the reason I say that is because if you look at the analysis of the California Supreme Court decision which led to Proposition 8, that analysis was that the deprivation of the title marriage, and in that case they were dealing with another proposition which prevented California from recognizing same-sex marriages from other states. The court's analysis there was identical to this court's analysis and opinions of the justices. And so the reason I say there's some doubt is because if, in fact, Proposition 8 is ultimately invalidated, and as you know, right now that litigation is in flux, the Supreme Court's analysis in California suggests that this scheme is unconstitutional in California. It won't matter because, obviously, persons who are under that scheme can probably then choose to marry, just as they can in Massachusetts. Technically, the answer would be if they had stayed in California under that scheme so long as it remains in place and isn't challenged, yes. But again, the analysis that the California court uses, the identical analysis this court used in opinions
As of right now, the answer is yes.
As of right now, the answer is yes, because as of right now, even though the Ninth Circuit has ruled that Proposition 8 violates the federal Constitution, all of that's been stayed. It's the subject of a petition for rehearing. It probably is going to end up going to the Supreme Court. So,
but if it's unconstitutional, it's only because it doesn't go far enough. So why should we say, because we don't believe that separate but equal with regard to this matter is going to be sufficient, that we would not recognize a civil union equivalent?
I'm not sure I understand the question, Judge.
The reason why, in the opinion of the justices, we didn't accept the view that a civil union was equivalent to marriage is because we essentially said it's separate, but it's not equal. We don't think that's enough. Why would we, given the reasoning and opinion of the justices, not recognize a state which decides that civil union is appropriate?
Because, again, the reasoning and opinions of the justices was that it violates our Declaration of Rights. It's not simply that it's not enough. The analysis was focused on the stigma that results from imposing these obligations under a scheme which is marriage in all but name, and that was the core of the analysis. So that ties in, by the way, Justice Gantz, with our point that here, in this case, there was an abundant and ample opportunity to fix the problem, to avoid this constitutional problem by marrying. That was available to these parties from June 2007 to, I will take the time the relationship fell apart, 14 months later. So not only do you have somebody trying to obtain parental rights and obligations under something which clearly does violate the Massachusetts Declaration of Rights, but they had ample opportunity to take advantage of the lawful means which doesn't violate the Constitution. This case isn't one where there was a barrier or a hurdle of some kind to doing that. The only reason they didn't marry was this financial reason so that my client would be on Mass Health in Massachusetts.
Really, the reasons really are not that important, I think, about why they chose not to marry. It wasn't because they couldn't. It was a question of whether they needed to.
Exactly.
And I, following up on Judge Gantz's question, we've recognized marriages in Massachusetts that we would not allow to have performed in Massachusetts. For example, underage marriages, common law marriages. It's not because they would be legal marriages if they were performed in Massachusetts or done in Massachusetts, but simply we have recognized them from other jurisdictions. How is this any different?
Here's the difference, Justice Link. In none of those cases, in none of them, did any of those arrangements violate constitutional rights in Massachusetts.
What constitutional rights do they violate in Massachusetts? What constitutional rights? Whose constitutional rights would be violated by recognizing a spousal relationship or a spousal equivalent relationship?
Again, accepting this Court's analysis and opinions of the justices, the adult and the child. Because, again, the focus was on this stigma. That's the reason the Court said that you can't have this civil union in Massachusetts.
But aren't we focusing on the relationship of the parents and the children here? It's not the stigma to the rest of the world, so.
That's right. But, again, you could say that about any civil union relationship. The point being that these parties only entered into this relationship in California because they couldn't marry. They came to Massachusetts. They had ample opportunity to get outside this arrangement and to achieve these parental rights and obligations through a method which is recognized under our Constitution after Goodridge, and they chose not to do so. There was no barrier or hurdle to doing that. And as I said, the child doesn't have any role in that decision. So the Court, again, recognized in opinions of the justices that this is a stigma that is a burden not only on the adults, but it's also on the children. And again, as I say, I think the primacy of the Massachusetts Constitution, which, by the way, this Court, if you go back as far as 1916, in the Perkins v. Perkins decision, said that comity is a matter of several issues, including the requirement that the Court must focus on the rights of the residents of the state. That's the difference, for example, with the Cody Whiteacre decision, which, as we know, I know there was disagreement on the Court about the analysis and result there, but in that case, there was only non-residents of Massachusetts who were choosing to come into Massachusetts and avail themselves of the right to marry and then to go back and leave. So that didn't involve rights of residents of the state. This case does. That's the difference. So again, we submit that where there's ample opportunity to take advantage of something that raises none of these constitutional questions and doesn't impose that stigma on the child, that should trump the effort to achieve those same rights and responsibilities through using something which does violate the Constitution. If I may move to the custody issue, because there is a significant issue here involving transfer of custody. And this is regardless of the outcome on the issue involving parental rights and obligations. As we know, in Massachusetts, it is required that a court, in determining custody, particularly a transfer of custody, must evaluate all of the relevant factors in determining a child's best interests. That was not done here in two respects. First, it was undisputed. In fact, it was found by the court that Jay has a close relationship, a close bond with her mother. It makes sense because Jay had lived with her mother for her entire young life. The court, however, said nothing about that in evaluating the impact on Jay of this rather abrupt transfer of custody. When it ordered that transfer, it said nothing about it. The testimony was even stronger than the court's finding. The plaintiff, to her credit, conceded that Jay and her mother are extremely close and that a change in custody would be very difficult for her. The court simply disregarded that. I submit that that alone infects with reversible error the court's determination of Jay's best interests in ordering a transfer of custody. But there's more than that. The court also held, and this was a curious phrase in a best interests transfer of custody case, the court also determined that it was more likely than not that Jay had suffered harm from this move to Oregon. That's not a finding of harm. And the reason the court didn't go further than that was because all the court could do was it cherry-picked a few isolated instances of Jay having some aggressive behavior after she left Massachusetts and went to Oregon. Against that, there was a ream of unrefuted evidence which came from my client and her witnesses regarding Jay's development, her well-being, how she was faring in Oregon. Now, that was rejected by the court, apparently on credibility reasons. It wasn't refuted by anything. It was rejected by the court apparently on credibility reasons. And while that may be within the realm of the court's authority in deciding what the facts are in a case, there's a problem. It leaves a big void. That void here was filled by a report that was filed by an individual, an impartial observer who was appointed by the court as a GAL next friend for the two children. And what that individual did was observed Jay at the first ordered supervised visitation back from Oregon 10 months after the move, filed a report based on what she observed. And here's what she observed. This isn't recommendations. This isn't guidelines. These are facts that were filed with the court by this impartial observer that the court had appointed.
Is the judge obliged to credit those facts?
In this circumstance, Justice Lenk, I say yes. And here's the difference from, for example, Mason v. Coleman, where the court held that a trial judge need not adopt any or all or most of the findings and recommendations of an investigative GAL. In that case, in Mason v. Coleman, there was a full exploration of the children's best interests in the removal there. Here, what we're saying is that you've got these facts, not recommendations, not analysis. You've got these facts.
You say facts. Aren't they really conclusions?
They're her observations of a healthy, well-behaved, verbal child. She's reporting her interaction with adults, her active play with the other child. So I submit those are facts, certainly.
And you submit that the judge was bound to accept each and every one of those.
Where there's nothing challenging it, and there's nothing about that which is facially incredible or impeachable, and where, as I said, if you get rid of that, and you get rid, as she did, of all of the unrefuted evidence regarding how things were going in Oregon, you've got nothing. That's why she said, it's more likely than not that she suffered harm from the move. That's speculation. And if you're going to transfer custody in this state, I can't find a case where that sort of approach, that incomplete approach to best interests has been used. That's speculation. And then she took it further and she speculated that there would be further harm unless this transfer took place. Compare what that person filed in that report about what she observed with what the plaintiff's expert witness testified you would get from a child who is experiencing harm. You have eating problems and disorders, you have sleeping disorders, there's withdrawal, there's inability to interact in a healthy way. Exact opposite of what was observed here. So we're saying in this limited situation where you have an obligation to fully assess this child's best interests, and you don't have any evidence on whether or not that move has in fact caused the child harm, but you have it in the form of this report, then you have to look at something. You can't just throw your hands up and speculate and say it's more likely than not that she suffered harm.
Can I ask you, what is this, was that portion of the order stayed pending appeal?
No.
So
what portion of the order?
The transfer of custody?
No. In fact, what happened was the judgment came down on April 20th. It ordered a custody transfer by April 24th, which was Easter Sunday. We filed a handwritten motion for stay with the probate judge on April 20th. That was denied. I got asked to put together an application to the single justice of the appeals court. That was filed on the morning of April 22nd, and we got an order that afternoon under Rule 6 denying a stay at that point. I think it was
What year was that?
Pardon?
What year was that?
That was last year. It was April of 2011. The dates are April 20th was the judgment and the request for stay from the trial court, April 22. The transfer was supposed to take place on April 24th. That's what ended up happening. My client, the judge said she's unemployed. Well, what she did was she had this residency in Michigan. She put that off for a period of time to come here and ease with the transition. She then went back to Michigan. She now has a residency there under this National Health Service Corp program in psychiatry. She has a job opportunity with a hospital in Lansing. But there was, for that period where she was deemed unemployed, was because she had to come out here for the transition.
Can I ask you a somewhat unrelated question, really related to the second child, M?
Right.
How does the order affect her? Does it declare that the two parties here are her legal parents?
It declares, what it does is it declares under this RDP scheme, each party is the legal parent of the other's child.
And I take it it's your position that under Massachusetts law, because this was a child, the product of artificial insemination, and there had not been specific written consent for that procedure, that under Massachusetts law, the second child would not be the child.
That's correct, even if you get over the first hurdle.
Okay. What about under California law?
That, whether or not, that also requires consent. In fact, it was an issue.
Also requires the
yeah,
same
in fact,
written
it was an
consent.
issue in the case regarding the consent by the plaintiff to my client's procedure, where there's a checklist and there's one item not filled off, which is the consent form.
Okay,
That was
so
an
the
issue.
law is the same in terms of what one has to do.
Generally, I would say it's the same.
All right, thank you.
Time is up.
Thank you very much.
Good afternoon, Your Honors. May it please the Court, my name is Karen Lowy, and I'm here on behalf of the plaintiff appellee, Amy E. Hunter. The children before the court, J and M, were brought into the world by two parents who once shared a strong commitment to each other and worked hard to form and secure a family. Their two mothers, Ms. Hunter and Ms. Rose, solidified their commitment to each other by entering into a registered domestic partnership in California, a fully comprehensive spousal status under that state's law.
Is it your position that if someone has entered into such a partnership, there are a number of states that permit it in different forms, that we should recognize that as a full marriage and apply all of our marriage law to those relationships here?
While it would certainly be our position that parties who have entered into a spousal relationship should be treated as spouses for all purposes here in the Commonwealth.
Regardless of what the rights and protections they may have had under their individual state law.
Well, the kinds of statuses that we're talking about here, Your Honor, like that of California, do in fact provide all of the protections that spouses receive under that state's law.
So we need to look to the law where the partnership is registered to decide what law we should apply, or we just say, no, you're a registered domestic partnership in some other state, you come here, you're married. So we apply all of our laws that relate to married people here.
When the Commonwealth determines that parties have entered into a fully comprehensive spousal status in another state, you have to make that, absolutely, Your Honor. I wouldn't suggest that this would apply to a state that provides merely sort of the opportunity for public employees, for example, to have employment benefits. The kinds of spousal statuses that we're talking about here are those like that of California that include parties to a registered domestic partnership within all of the protections that spouses receive under that state's law. Once this court extends comity to that relationship, then yes, it would be our position that Massachusetts's protection for spouses should apply to that relationship as well. To be fair, however, the issue before the court is truly narrower. The parties before the court here are asking for their relationship to be recognized as importing the protections of spouses, both for purposes of its dissolution and most critically for the purposes of protecting the children that have been born into that relationship. Here, the trial court appropriately did exactly that and recognized the parties' spousal relationship and proceeded to address both the dissolution.
May I interrupt you? Now, Mr. Foskett cites to opinion of the justices to support his position. How do you respond to that?
This court's conclusion in opinions of the justices that a lesser spousal status could not remedy the constitutional violation of Goodridge is truly a separate matter from the relevant inquiry under comity. The relevant inquiry under comity is whether whether the parties have established a valid spousal relationship in another state. And if they have, how the Commonwealth is going to recognize that relationship. In this instance, there is no public policy against recognizing this spousal status that California has created. And in fact, all of the public policies around why this Commonwealth has always extended comity to spousal relationships come to bear here. Most critically around, in the language of inhabitants of Medway versus inhabitants of Needham, preventing the disastrous consequences to children who are born into that relationship. And as well in honoring the intentions of the parties who entered into that relationship and as a matter of mutual respect for the determinations of our sister states. Here, what the trial court did was entirely appropriate in recognizing the spousal status of the parties and recognizing the joint parentage of each of the parties for both of the children that were born into this relationship. Picking up on Justice Cordy's questions about the kind of consent that is required, here the trial court appropriately applied General Laws Chapter 46, Section 4B, a statute that has no written consent requirement, in recognizing that here each of the parties provided consent to the other's assisted insemination, and the children were born into the relationship, and therefore under that statute, both parties are established as legal parents.
But that's only if the spousal relationship is recognized as, if comity is extended.
That's true, Your Honor. There are two options for how the court might address the parentage issue. One is, as the trial court did, which was appropriately to extend comity to the relationship and then apply Massachusetts laws regarding spouses to that relationship. If the court were to determine, however, that the Massachusetts spousal protections couldn't apply to the relationship, then the court could nonetheless look to the California protections that have been accorded to registered domestic partners with regard to the children born into the relationship. Either way, the result is the same.
Let me ask you, Mr. Foskett says, well, they could have married, but they chose not to do so. How do you respond to that?
I think Justice Link correctly identified the relevant inquiry here. The question isn't whether they could have, the question is whether they had to. We don't ask parties to duplicate their spousal status when they cross state lines. We recognize, as a matter of comity, a validly established common law marriage that has been entered in another state, where there has been no marriage license issued, there has been no solemnization, but because another state recognized those parties as spouses, we treat them as spouses without requiring them to apply for and obtain a marriage license here in the Commonwealth. The parties had a spousal status when they moved here to the Commonwealth and had every reason to believe they would continue to be treated as spouses regardless of the fact that they had left California, which was the state that established that status. This court has recognized, again, in Medway versus Needham, the chaos that would result from people being able to disavow their spousal status simply because they have crossed state lines. And here the parties, again, entered into this fully comprehensive spousal status. Had they remained in California, they would absolutely have been both declared to be parents of these two children. And the same result should be here in the Commonwealth, despite the fact that they have moved here.
Would they have had to have done anything in California by way of consent forms in order to have them both be parents of both children?
There are two separate bases of parentage under California law that are relevant. Under California Family Code Section 7613, there is a written consent requirement, and as the trial court found here, particularly with regard to the older child Jay, Ms. Hunter and Ms. Rose both signed the relevant consent form to Ms. Rose's insemination.
So the question is more as to M, though.
So the question is more as to M. Again, there was a written consent here filed with here in the Commonwealth with one of the facilities from which Ms. Hunter sought treatment.
But that's not the facility at which she was able to achieve a pregnancy.
At the end, that's true, Your Honor. But California Family Code Section 7613 is only one of the bases of her parentage. The other is California Family Code Section 7611, which has a presumption of parentage for children born into spousal relationships in that state. And biology is not determinative of the outcome under that statute.
Will you tell us about the issue of the custody?
Absolutely, Your Honor.
I hear Mr. Foskett say that the judge did not fully assess the best interests of the child.
That assertion, Your Honor, does not bear up upon closer scrutiny of both the extensive fact-finding made by the trial court and its ultimate judgments and determinations.
What about the guardian ad litem's report that he says the judge was obligated to accept?
It's particularly a surprising argument given the role that the guardian ad litem was actually playing here. This was not an evaluative guardian ad litem. This was an attorney appointed to represent the legal interests of the two children. The report that Mr. Foskett is referencing is not a part of the factual record of this case. It was submitted to the court, but it was not the basis of the court's fact-finding. In fact, what the guardian ad litem ultimately submitted to the court in terms of proposed findings and judgments was a proposal that, in fact, supported what the trial court did here in issuing its judgments. There's no question that the
It's not part of the record?
It was submitted, Your Honor, but it was not a part of the facts established in this case.
Submitted into evidence, is that what you mean?
It was submitted to the court, but it was not something that was considered as a part of the court's fact-finding.
Was it docketed?
It was docketed.
Is it before us?
It is before you.
Okay.
So why wasn't it considered, ordinarily a GAL report would be considered
Ordinarily,
as part of the record?
Yes, Your Honor, but she was not serving as an evaluative fact-finding guardian ad litem. She was there as attorney for the children.
So did you say that it was the item that was docketed a statement of proposed findings of fact?
They're two separate issues, Your Honor. There was a report that the court asked the guardian ad litem to submit. It was submitted, but then it was not something that was utilized by the court as the basis for fact-finding.
In the multi-day trial, it was never entered into evidence?
Never. Never, Your Honor. The second piece that I was referencing, Your Honor, was the proposed findings of fact, proposed conclusions of law, and proposed judgment that all of the attorneys in this case submitted. And in that instance, what the guardian ad litem submitted was a proposal that mirrored in many ways what the court actually did. Regarding the court's best interests analysis here.
In guardian ad litem?
Yes, Your Honor.
She made proposed findings?
She did.
She made proposed findings, but she wasn't an evaluator.
She was not proposed findings of fact and law the same way any other attorney in the case would have submitted.
For the judge to make.
Exactly right. Proposed findings for the trial judge to consider.
Were these as to the legal issues regarding the status of the children and vis-a-vis a spousal relationship, or did these involve the domestic partnership aspects of this, or?
To some extent, yes. The proposed findings, like those submitted by both parties as well, ran the full scope of both legal and factual issues in the case.
Okay, so it ran the gamut.
It did.
Okay.
It did, because the role of the guardian ad litem was to act as attorney for the children. And like the other counsel in this case, that's exactly what all parties here submitted were proposals for the court to consider. What the trial court actually issued in the end absolutely reflects a full, comprehensive evaluation of all of the relevant aspects of these children's best interests.
What about the point that Mr. Foskett makes with respect to not having acknowledged the nature of the close relationship between Jay and her biological mother?
That's belied by both the findings of the court and, in fact, the actual judgment of the court. The trial court here took extensive measures to preserve and protect the relationship between Jay and Ms. Rose, including granting joint legal custody to the parties, granting extensive parenting time that not only exceeded the amount that the plaintiff's expert testified was necessary to preserve the bond, but was also more than Ms. Hunter had throughout the pendency of the litigation. The court specifically addressed the need for Jay's transition and addressed the period of time in between the allocation of primary physical custody to Ms. Hunter and the time that Ms. Rose was supposed to be starting her residency. And the court made certain that Ms. Rose and Jay would continue to have ongoing contact and parenting time. As this court recognized in custody of Callie, we look to the substance of what the judge did in making its best interests analysis, and here the judgment of the court is very clear in recognizing the importance of preserving that bond. As far as the other aspects of the best interest analysis here, the court made thorough findings, 88 pages of fact-finding, in fact, that really evaluated every aspect of the parties' capacities to address the best interests of these children. And the findings of that court recognized the stable, child-centered care of Ms. Hunter, along with her ability to support Jay's relationship with her other parent, and by contrast found that there was likely to be substantial harm from Jay remaining in Ms. Rose's primary custody, given the instability of her care, her inability to prioritize Jay's needs over her own needs, as reflected in multiple decisions that she made throughout the course of this litigation, and Ms. Rose's active denigration and alienation of Jay from her other mother, Ms. Hunter. Given that full scope of issues considered, there's no question that the trial court's analysis here comprehensively addressed the full range of best interests of these two children. The last matter I would address here, Your Honor, is that regarding the attorney's fees award to Ms. Hunter, which was an entirely appropriate exercise of the trial court's discretion and should also be affirmed. That order reflected the trial judge's consideration of the submissions of the parties, including the thorough, detailed affidavit of Ms. Hunter's trial counsel. Both parties had adequate opportunity to address the issue of attorney's fees and did so no evidentiary hearing was necessary here. The trial judge had extensive knowledge of this case, having presided over this heavily litigated matter over the course of 2 years and observing firsthand the skill of trial counsel.
How central to her finding is the finding that there's a relitigation of issues that had already been resolved?
That certainly was a large part of it, but it was not about the substance of those arguments, but about Ms. Rose's inability to comply and refusal to comply with orders of the court and the need to relitigate them, not just around the substance of her parentage position, but about several other collateral matters as well. Furthermore, what the trial court also credited was the amount of work required by Ms. Rose's obstructionist conduct, her refusal to comply with discovery requests, her spoliation of evidence, and all of the ways in which her litigation tactics prolonged this litigation unnecessarily. And in light of all of those reasonable considerations, there's no ground to disturb that.
There were no contempts, though, I take it.
There were no findings of contempt, but there were several motions that needed to be filed in order for compliance to occur. All of this is detailed in the papers, and in sum, the trial court's ruling here was correct as a matter of law and fact and should be affirmed. Thank you.
All right.